privacy and security aren't even mentioned. But that is our biggest problem, our biggest challenge as compliance officers is the privacy and the security rule and the breach notification rule to a degree as well. The problem with HIPAA and the problem with being a compliance officer, especially when we're doing like a risk assessment or we're assessing things at our organization, is there is no such thing as a perfect answer. This is a gray law. Everything is based on risk, reasonable and appropriate risk mitigation. So A does not equal B always. You have these standards and you have these implementation specifications. Okay, but the way you apply those to Bethesda Medical Center is going to be entirely different than how you would apply those to some tiny little doctor's office somewhere in southeast Georgia. But you still have to apply them. And if you're not applying a certain aspect of this, you have to explain why not. Everything has to be addressed. Even when you're not implementing something, you still need to address why it's not being done. Very, very important, because if audited by the government, those are the things they're going to be looking for. Have we been proactive? Have we covered all of the required standards and implementation specifications of this law? And I can't stress that enough. Being proactive, getting in front of this, getting those risk assessments done, getting those policies in place prior to something bad happening is absolutely critical. I cannot stress that enough. You do not want to be caught in some nasty breach or some employee does something very, very stupid with health records, they get in big trouble, practice ends up getting dragged into litigation, and we really have a weak to non-existent program to speak of. That's when we get in trouble. We do not have to be perfect, but we have to prove that we're making a real effort here. So a little bit like the boy who cried wolf, like I sort of alluded to earlier, this law has been around a long time, like the boy screaming wolf, 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 wolf never shows up. You eventually become desensitized to it until the wolf does show up. So the wolf, of course, being the fact that the law is being enforced proactively and the fact that more people now file complaints for HIPAA violations than ever before. That's because of the individual remedy, which I'll talk about in a minute. But I've been doing this a long time, and there's not a week that goes by that I don't get at least one call from an attorney, either prosecution or defense, that's suing or being sued in whatever state, and they need to know, was this thing that happened, does it constitute a federal HIPAA violation? Nobody can sue under the federal law, but you use that as the foundation of a state case against the organization. And that's something the federal government in 2013 told the states to implement. So a pretty big deal. I also get calls from groups, again, of all shapes and sizes, stating, oh no, we're being audited by the Office of Civil Rights for HIPAA. What do we do? What do we do? So this is now a proactive enforced law, not like it used to be. It's not just based on a breach or a complaint. It's proactive. So when everything changed was September 23rd, 2013, and I know that's 4 and a few months ago, 4 years and several months ago, but when you think of HIPAA, that's really when the real rubber hit the road here. So prior to that date, HIPAA was more like this little poodle. Yes, it has teeth, yes, it can bite, but not an imminent threat, not like a honey badger. These things are very aggressive, very proactive. That's sort of how the law works these days. And again, I jest with the pictures, but it seems to liven things up a bit here. So 9/23/2013, let's talk about that for a minute. That's D-Day. That's when the final HIPAA Omnibus Rule came out. So what it did is it increases penalties. And something you need to understand as compliance officers is the burden is now equal between business associate and covered entity. That's a really big deal, because if you're a business, for example, you have to monitor the covered entity in which you're doing business with, at least in the way in which you're doing business. For example, and this is a live case I actually worked. So if there was an outsourced medical billing company. They were working with a large orthopedic group. The orthopedic group was letting this billing company into their electronic health record system, which was maintained on a server at their local practice, through a non-encrypted port open on the firewall. That is a violation under HIPAA right there. That's number one. Number two, they were letting the business in using one username and password into the electronic health record system. That's a violation again. Multiple violations here. A breach occurred because that the covered entity was granting to the business. The breach happened to the business. Now, both groups are held accountable under the law because a business has a responsibility to say, no, we cannot access you